we are going to be discussing cease and desist letters, and we are going to talk about the Twitter cease and desist letter to Meta regarding the Threads app, and the do's and don'ts for you, the entrepreneur, after receiving a cease and desist letter. Hello, entrepreneurs, technology startups, and investors. Welcome to another episode of Tip Top Startups. I am your host, David Nima. I'm one of the top trademark and technology attorneys in the United States. I'm also the founder of Tip Top Startups Academy, where we provide legal and business coaching on social media, as well as on through my books, as well as one-on-one coaching for anyone that is launching a tech startup business. Make sure to like and subscribe at Tip Top Startups on YouTube and Instagram. In today's episode, we are going to be discussing cease and desist letters, and we are going to talk about the Twitter cease and desist letter to Meta regarding the Threads app, and the do's and don'ts for you, the entrepreneur, after receiving a cease and desist letter. So let's get right into it. As you know, last week, Meta launched the Threads app, and Twitter sent a cease and desist letter threatening legal action against Threads in connection with potential trade secret misappropriation. Now, of course, we discuss trade secrets in Tip Top Startups as well as Tip Top Trademarks. Make sure to check those out if you want to learn more about trade secrets and the differences between that type of intellectual property versus trademarks and copyrights and patents. Those are the four types of intellectual property that most companies seek to protect. So this cease and desist letter is concerning the trade secrets of the company. And here's a copy of the cease and desist letter, and we can kind of look at it together in connection with kind of discussing what is a cease and desist letter. So a cease and desist letter is not a judgment, right? It hasn't gone through litigation. There's no court involved. There's no judge involved. Usually a company or a lawyer on behalf of a company sends out a cease and desist letter as a private correspondence or a direct correspondence, which is not private specifically, not confidential, but a direct correspondence that is received by the receiving party, and it usually just demands certain things, right? So, or, threatens, it says right here, it says, we demand that Meta take immediate steps to stop using any Twitter trade secrets or other highly confidential information. So usually the elements of a cease and desist letter are kind of talking about who the person is that's sending the cease and desist letter, like I'm writing on behalf of X Corp, a successor of interest of Twitter Inc., or you might say I'm the attorney for X Corp, for example. Then you provide some details about some background about what the context here is. And as well as with that knowledge, Meta deliberately assigned these employees to develop in a matter of months Meta's copycat Threads app with the specific intent that they use to it. So they're making allegations here. So it makes certain allegations. As Twitter knows that all these employees previously worked at Twitter, that these employees had and continue to have access to Twitter's trade secrets and other highly confidential information, that these employees have ongoing obligations to Twitter to maintain the confidentiality of these information. So it's essentially saying that we have learned, or we suspect, or we allege that Twitter or Meta has been using the confidential information of Twitter, and the way they've received this confidential information is by hiring former employees of Twitter who are bound by confidentiality. Even though they have left Twitter as an employee, they're still bound to the trade secret confidentiality clauses, and they're alleging that Meta, these new employees are violating that confidentiality agreement, and therefore Meta is responsible. So that's kind of what the cease and desist letter, usually any cease and desist letter says. It says, please consider this letter as formal notice that Meta must preserve any documents that could be relevant to the dispute of Twitter employees, and that includes but not limited to all documents in recruiting, hiring, and that Meta is competing threats. So they're saying that we are potentially thinking about doing litigation against Meta, and that you have a duty to preserve any documentary evidence. So that's relatively what a cease and desist letter is and how it applies in this context of Meta receiving a cease and desist letter from Twitter, again, in connection with former Twitter employees right here, former Twitter employees that are now working at Meta and have potentially or allegedly misappropriated or used the trade secrets that they were privy to during their time at Twitter, which of course belongs to Twitter, and now they're using it for Meta. This constitutes intellectual property infringement. Therefore, there's potential lawsuit here, and therefore this is why they have sent out this cease and desist letter. So now let's talk a little bit about the do's and don'ts for entrepreneurs after receiving a cease and desist letter. In my career, I have sent and received many cease and desist letters on behalf of my clients. And sometimes when I send out a cease and desist letter, I receive a response directly from the owner of the company who is not a lawyer. And we have sent the letter to the owner of the company, and that person responds directly to us without potentially consulting a lawyer. And I have seen some mistakes or actions that these people make when they respond to the cease and desist letter that I'm going to talk to you about. The first thing that you don't want to do in any response to a cease and desist letter is make any admissions. You don't want to say things like, you're correct, we are misappropriating this. Okay, you don't want to make any admissions. You generally want to deny the allegations to the extent that you have grounds to deny them, and you got to consult with an attorney on it. But what you don't want to do is just make any admissions. You also don't want to apologize. Apologizing can imply that you've done some type of wrong action. So in case that your response becomes public, becomes evidence in a potential lawsuit, the fact that the response includes an apology may imply or convince a judge or jury that you knew of your wrong actions, or at least you've admitted to them. So it can be an implied admission by making an apology. The other thing that you don't want to do is make changes to your product or website without first consulting an attorney. Let's say, for example, a cease and desist letter says, your website has the colors black and blue, and these are our proprietary colors. Therefore, we're asking you to cease and desist using our proprietary colors and make changes and use some other alternative color. What you don't want to do is immediately make those changes. That can also be deemed a potential implied admission. Now, of course, if the conduct that you're engaged in is problematic and you might be subject to some significant fines and penalties if the infringement continues, you'd certainly want to consult with an attorney and plan to make changes sooner than later. Nevertheless, making changes can potentially be deemed an admission of wrongdoing, an admission of guilt, and therefore it's wise not to make changes until you've consulted with an attorney. And as you can see, the final point here is to consult with an experienced attorney that can advise you on the strategy of how to respond to this cease and desist letter. What you don't want to do is, like I said, make these unilateral admissions and changes that can potentially, add more liability to the case for the other side, which you're going to have to potentially hire an attorney to defend you on anyway. So the cease and desist letter is one of the top reasons that you would go out and seek out an attorney if you don't have one on call, so that you can discuss the nature of the allegations in the cease and desist letter and the resolution plan for your business. So that's a little bit about cease and desist letters and the do's and don'ts of cease and desist letters for technology startups. I hope that you've enjoyed this video, and make sure to like, share, and subscribe to Tip Top Startups on YouTube and Instagram, where we provide daily tips for entrepreneurs and investors in connection with legal and business due diligence in the technology space. I'm your host, David Nima, and I will see you in the next episode.